I stood on my back deck watching the last of the water drain from my private lake, and I felt something inside me break that had nothing to do with sadness and everything to do with white-hot rage. The property I owned in northern Idaho, just outside of Coeur d'Alene, had been in my family for 3 generations. My grandfather, Nathan Young, had purchased this 100-acre parcel back in 1952, complete with a natural spring-fed lake that covered about 15 acres of the land. When he died, it passed to my father, and when my father passed 5 years ago, it came to me. My name is Nathan Young, Jr., and I had always planned to retire here, maybe build a small cabin resort, live out my days in peace. I was 42 years old, worked as an environmental consultant in Seattle, and this property was my escape, my inheritance, my future. That future was currently draining into a hastily dug channel that led off my property. I had been in Seattle for the past 2 weeks, working on a major project for a tech company that wanted to build a new campus. When I got the call from my neighbor, Bill Henderson, telling me something strange was happening at my property, I immediately took personal days and drove the 5 hours to Coeur d'Alene. What I found made my blood boil. A construction crew was on my land without my permission, and they had somehow breached the earthen dam on the south side of my lake. Water was pouring out at an alarming rate, and the lake level had already dropped by at least 6 feet. Equipment was everywhere, including excavators, dump trucks, and surveying gear. Men in hard hats walked around like they owned the place. I stormed down from my small caretaker's cottage, the only structure on the property, and confronted the first person I saw who looked like they might be in charge. "What the hell's going on here?" I shouted over the noise of the machinery. "This is private property!" The man, a burly guy in his 50s with a clipboard, barely glanced at me. "You need to talk to the HOA. We're just following orders in the permits." "What HOA?" I demanded. "I'm not part of any HOA." He shrugged. "Not my problem, buddy. Take it up with Cascade Springs HOA. They hired us. Everything's legal. We got permits from the county." I felt my hands clench into fists, but I knew better than to assault someone, even if they were destroying my property. Instead, I pulled out my phone and called the sheriff's office. Within 20 minutes, a deputy arrived, a young woman named Deputy Martinez, who listened patiently to my explanation. "Sir, I understand you're upset," she said, "but they're showing me valid permits from the county planning department. The permits list Cascade Springs HOA as the applicant, and the land description matches this location. But I never agreed to any of this." I pulled out my phone and showed her the property deed I kept in my digital files. "Look, this is my land, my name, my deed. I inherited it from my father." Deputy Martinez examined my documents, then looked at the permits again. Her expression shifted from professional neutrality to concern. "Mr. Young, I think there might be a serious problem here. These permits show the HOA as the property owner, but your deed clearly shows you as the owner. This needs to be sorted out immediately. I'm going to halt the construction until this gets resolved." The construction foreman was furious, but Deputy Martinez was firm. She ordered everyone off the property, though she noted that she couldn't make them undo what they had already done until a judge made a ruling. I watched helplessly as the crew packed up and left, leaving behind the devastation they had caused. My lake was still draining, though more slowly now. Maybe a quarter of the water was already gone. That night, I sat in the cottage and did research. Cascade Springs HOA, I discovered, was a newly formed homeowners association that had been created just 8 months ago. The development was planned for the area adjacent to my property on the east side. The land there had been sold by a different family, the Hendersons, Bill's cousins, who had owned about 200 acres. They had sold it to a development company called Summit Ridge Developers. But why were they on my land? The next morning, I drove into Coeur d'Alene and went straight to the county planning office. The clerk, an efficient woman in her 30s, pulled up the permits on her computer. "Yes, here we are," she said. "Cascade Springs HOA, approved for a mixed-use development including townhomes, a community center, and recreational facilities. The permits include water management infrastructure." "Can you show me the exact property description?" I asked. She turned the monitor so I could see. As I read the legal description, my stomach dropped. The description was intentionally vague in some areas, but included specific coordinates that clearly encompassed my property, including my lake. Someone had deliberately filed permits using a property description that included land they did not own. "This is fraud," I said flatly. "I own that property. I never sold it, never agreed to be part of any HOA, and never gave permission for any of this." The clerk's eyes widened. "Oh my, that's very serious. You need to speak with our county attorney right away." She made a call, and within an hour I was sitting in a small conference room with the county attorney, a sharp-eyed woman named Patricia Owens. I showed her my deed, the permits, and explained what had happened. "Mr. Young, this is indeed fraud," she said grimly. "Someone has filed for permits using a false property claim. However, I have to tell you that the county issued these permits in good faith. We'll cooperate fully with your legal action, but you're going to need to file suit against the HOA and the developers to resolve this." I left the county building with a splitting headache and a growing sense of dread. Legal battles were expensive and time-consuming, but I had no choice. I called a real estate attorney in Coeur d'Alene named Richard Castellano, who came highly recommended. He agreed to see me that afternoon. Richard was in his 60s, with gray hair and the demeanor of someone who had seen everything. He listened to my story, examined all my documents, and then leaned back in his chair. "Nathan, you have a very strong case," he said. "This is blatant fraud and trespass. However, I need to warn you that these HOA battles can get ugly. If there's money involved, and there clearly is with a development of this size, they're going to fight back hard." "I don't care," I said. "That's my land, my family's land. They had no right." "Agreed. Let me file an emergency injunction first thing tomorrow morning. We'll get a temporary restraining order against any further construction, and we'll demand they restore your property to its original condition. Then, we file a full lawsuit for damages, fraud, and trespass." As I left Richard's office, my phone rang. Unknown number. I answered anyway. "Is this Nathan Young?" A woman's voice, syrupy sweet but with an edge like broken glass. "Yes. Who is this?" "My name is Patricia Whitmore. I'm the president of Cascade Springs HOA. I understand there's been a little misunderstanding about the construction project." "A little misunderstanding." My blood pressure spiked. "There's no misunderstanding," I said coldly. "You trespassed on my property and destroyed my lake without permission. That's called a crime." "Now, Mr. Young, let's not be hasty," Patricia said, her voice taking on a condescending tone. "The development company filed all the proper paperwork. If there was an error in the property description, I'm sure we can work something out. We're prepared to offer you a very generous settlement to resolve this quickly." "I don't want your settlement. I want you off my property and I want my lake restored." "That's not going to be possible," Patricia said, and now the sweetness was gone entirely, replaced by pure ice. "You see, we've already invested over $2 million into this project. The townhomes are going to be built, Mr. Young, with or without your cooperation. That lake was an obstacle to proper drainage for the development. It had to go." "You had no right," I said, struggling to keep my voice level. "And you're going to learn that very quickly." "I don't think you understand what you're up against," Patricia said. "Cascade Springs HOA has very deep pockets and excellent legal representation. If you fight this, we'll bury you in legal fees until you have nothing left. Take the settlement, Mr. Young. It's the smart play." I hung up on her. That night, I couldn't sleep. I kept thinking about what Patricia had said. She was probably right about one thing: legal battles were expensive. But I had something they didn't know about, something I hadn't even thought about in years until tonight. The water rights. My grandfather had been a meticulous man, and when he bought this property, he had also secured the water rights to the underground spring that fed the lake. In Idaho, water rights were serious business, governed by the prior appropriation doctrine: first in time, first in right. My grandfather had filed his water rights claim in 1953, and it had been maintained ever since. I had the documents in a safety deposit box at a bank in Coeur d'Alene. If I owned the water rights to the spring, then I controlled the water. And if the HOA had drained my lake, they had interfered with my water rights. More importantly, if they were planning to use that water for their development, they would need my permission. The next morning, I retrieved the water rights documents from my safety deposit box and took them straight to Richard's office. His eyes lit up when he saw them. "Nathan, this changes everything," he said, spreading the documents across his desk. "Your grandfather filed for these water rights 73 years ago. They're senior rights, which means they take priority over any newer claims. If the HOA is planning to use this water source for their development, they can't do it without your permission." "What does that mean practically?" I asked. "It means we have leverage," Richard said with a grim smile. "Let me do some research on their development plans." Over the next few days, Richard's paralegal dug into the public records for the Cascade Springs development. What they found was damning. The entire development was designed around using the spring water that fed my lake. The plans showed the water being diverted into a series of retention ponds that would serve both as decorative features and as part of the stormwater management system for the townhomes. Without that water source, the development couldn't meet the county's requirements for water management. Richard filed the emergency injunction on a Thursday morning. By Friday afternoon, we were in front of Judge Robert Chen in the Kootenai County Courthouse. The HOA's attorney, a slick-looking man in his 40s named Douglas Barrett, argued that the construction had been done in good faith based on county permits, and that any property dispute should be resolved through a civil suit, not an injunction. Richard stood up and calmly presented my property deed, the water rights documentation, and photographs of the destruction to my lake. "Your Honor," Richard said, "the defendants deliberately falsified property descriptions to obtain permits for construction on land they do not own. They have destroyed a natural lake that has existed on my client's property for over a century. More critically, they have interfered with my client's water rights, which date back to 1953 and are senior to any other claims in this area. The defendants' own development plans, which I am submitting to the court, show they intend to appropriate this water source for their project. This is not a simple property dispute. This is fraud, trespass, and theft of water rights." Judge Chen was a no-nonsense jurist in his late 50s, and he did not look pleased as he reviewed the documents. He asked Douglas several pointed questions about how the HOA had obtained the permits with a property description that included land they didn't own. Douglas fumbled through his answers, clearly caught off guard. "I'm granting the injunction," Judge Chen finally said. "All construction is to cease immediately on the disputed property. Furthermore, the defendants are ordered to take immediate steps to prevent any further drainage of the plaintiff's lake and to develop a plan for restoration. We'll reconvene in 2 weeks for a full hearing on the matter. Mr. Barrett, I suggest your clients come prepared to explain how this situation occurred." I left the courthouse feeling like I could breathe again for the first time in days. But I knew this was just the beginning. That weekend, I hired a different construction crew to come out and repair the breach in the lake's earthen dam. It cost me $8,000, money I hadn't planned to spend, but it was necessary. The workers did good work, and by Sunday evening, the lake had stopped draining. The water level was still about 8 feet lower than it should be, but at least it wasn't getting worse. The spring would slowly refill it over time. On Monday morning, I got a visitor at the cottage. A silver Mercedes SUV pulled up, and out stepped a woman who could only be Patricia Whitmore. She was in her late 40s, with blonde hair styled in that particular way that screamed expensive salon, wearing a cream-colored pantsuit that probably cost more than my monthly mortgage. She had the look of someone used to getting her way. "Mr. Young," she said, extending a manicured hand that I didn't shake. "I thought it was time we met face to face." "You're trespassing," I said flatly. "Oh, don't be like that," Patricia said with a laugh that sounded like wind chimes made of knives. "I came here to talk sense into you. You won the injunction. Congratulations. But let's be realistic. You can't stop progress. This development is happening. We have investors, contracts, people who have already put down deposits on townhomes. If you continue to fight this, you're going to make a lot of powerful people very angry." "I don't care about your investors," I said. "You destroyed my property." "We'll pay for the damages," Patricia said dismissively. "What's a lake, really? We'll write you a check for $100,000. That should more than cover it." "It's not for sale." Patricia's expression hardened. "You're being unreasonable. Do you know who I am?" "My husband is Robert Whitmore. He's a senior partner at Whitmore & Associates, one of the largest law firms in Boise. We have connections at every level of state government. If you think you can win this fight, you're delusional. I have the property deed and the water rights, I said. Your development can't function without the spring water, and I control it, so I'd say I'm in a pretty good position. Patricia's face flushed red. You arrogant little man. Do you really think some dusty old water rights are going to stop us? We'll find another water source. We'll drill wells. We'll truck water in if we have to. Good luck with that, I said. Idaho water law is very clear. Senior rights take precedence. I checked, and there are no other significant water sources in this immediate area that aren't already claimed. You'd have to go miles away, which would make your project economically unfeasible. I had done my homework over the weekend, making calls to the Idaho Department of Water Resources and talking to a water rights specialist. Patricia didn't know it yet, but she was in serious trouble. We'll see about that, Patricia snapped. She turned to leave, then paused and looked back at me. You're making a big mistake, Mr. Young. A very big mistake. After she left, I called Richard and told him about the confrontation. He sighed heavily. That was a threat, Nathan. You need to be careful. People like Patricia Whitmore don't like being told no. Document everything from now on. If anyone from the HOA contacts you, record it if you can. Idaho is a one-party consent state, so that's legal. I took his advice to heart. Over the next week, things escalated quickly. I started receiving calls at all hours from blocked numbers, usually just silence or heavy breathing. Someone spray-painted "Sell Out" on the side of my cottage. My truck's tires were slashed one night. I reported everything to the sheriff's office, but without evidence of who was doing it, there was little they could do beyond increasing patrols in the area. The preliminary hearing arrived, and Richard had prepared a comprehensive case. We had documentation of everything: the property deed going back 3 generations, the water rights certificates, surveys showing the exact boundaries of my property, photographs of the damage, and estimates for full restoration that came to over $300,000. The HOA brought their own team of lawyers, 3 of them, led by Douglas Barrett. They argued that even if there had been an error in the property description, it was an honest mistake, and the county bore some responsibility for approving faulty permits. They claimed my water rights were irrelevant because they never intended to use the spring water for their development, despite their own plans showing exactly that. Judge Chen was not impressed. Mr. Barrett, I have the development plans right here. They clearly show the spring-fed lake as the primary water source for your stormwater management system. Are you telling me these plans are false? Douglas hesitated, then said, Your Honor, those plans were preliminary. We're revising them. When did you start revising them? Judge Chen asked. Before or after Mr. Young asserted his water rights? Silence. Judge Chen ruled in my favor on almost every point. The HOA was ordered to pay for complete restoration of my property, including refilling the lake if necessary. They were permanently enjoined from trespassing on my land or using any water from the spring without my written permission. And Judge Chen ordered the county to investigate how the fraudulent permits had been approved in the first place. I should have felt victorious. Instead, I felt exhausted and wary. People like Patricia didn't take defeat well. I was right to be worried. 2 days after the ruling, I received a certified letter from Summit Ridge Developers, the company actually building the Cascade Springs development. They were suing me for tortious interference with contract, claiming that my assertion of water rights had caused them to lose millions of dollars in potential profits. They were seeking $10 million in damages. Richard read the lawsuit and shook his head. This is a slap-suit strategic lawsuit against public participation. They're trying to bury you in legal fees and intimidate you into backing down. It's baseless, but defending against it will be expensive. How expensive? I asked, dreading the answer. Could be $50,000 or more, depending on how long it drags out. I felt sick. I had savings, but not unlimited amounts. This was exactly what Patricia had threatened burying me in legal costs. But then Richard smiled. However, Idaho has anti-SLAPP statutes. We can file a motion to dismiss and recover our attorney fees if we win. And we will win, Nathan. This suit is garbage. They're the ones who committed fraud, not you. Over the next month, Richard filed the anti-SLAPP motion while simultaneously pushing forward with my own lawsuit against the HOA and Summit Ridge developers for fraud, trespass, and damages. The discovery process began, which meant both sides had to turn over relevant documents. That's when things got interesting. Richard's paralegal, a sharp young woman named Jennifer, found something buried in the emails we obtained through discovery. It was a correspondence between Patricia Whitmore and the president of Summit Ridge Developers, a man named Marcus Drummond. In the email chain, they discussed how they knew my property was not part of the development parcel, but they had decided to include it anyway in the permit application because they needed the lake for water management and assumed I would either not notice or would be too intimidated to fight back. It was a smoking gun. Richard immediately filed an amended complaint adding claims for intentional fraud and conspiracy. He also sent copies of the emails to the county prosecutor's office and to the Idaho Attorney General's office, since filing false documents with a government agency could constitute criminal fraud. The response was swift and dramatic. The county prosecutor, a tough woman in her 50s named Catherine Mills, announced that her office was opening a criminal investigation into the permit fraud. Summit Ridge developers immediately threw Patricia Whitmore under the bus, claiming she had acted without their knowledge and had misrepresented the property boundaries to them. Patricia, in turn, hired her own criminal defense attorney and stopped communicating with anyone. The civil case proceeded to mediation, which was required before trial. We met in a conference room at a neutral attorney's office in Coeur d'Alene. On one side of the table sat me and Richard. On the other side were Marcus Drummond and his attorney, Douglas Barrett, representing Summit Ridge developers. Patricia Whitmore was conspicuously absent, having been removed as HOA president by an emergency board vote once the criminal investigation became public. The mediator, a retired judge named Harold Kenmore, laid out the situation plainly. "Gentlemen, let's be realistic. Mr. Young has clear title to his property and senior water rights that are essential to your development. The evidence of fraud is overwhelming. If this goes to trial, Mr. Young is going to win, and he's going to win big. The only question is how much it's going to cost the defendants." Marcus Drummond looked like he had aged 10 years in the past month. His company had halted all construction on Cascade Springs, and they were hemorrhaging money on a daily basis. The townhome buyers were demanding their deposits back. The investors were threatening their own lawsuits. "What do you want?" Marcus asked me directly, ignoring his attorney's warning look. "I want my property restored completely," I said. "I want compensation for my time, stress, and attorney fees, and I want an easement agreement that permanently prevents any development on a 50-foot buffer around my entire property boundary." Richard had coached me on this. The buffer zone would protect me from future encroachment and would significantly reduce the number of townhomes Summit Ridge could build, but it wouldn't make the development completely impossible. Marcus conferred with his attorney, then said, "We'll pay for restoration, attorney fees, and $250,000 in compensation, but we can't do the 50-foot buffer. That eliminates too many units. We'd lose money on the whole project." "Then you should have thought about that before you committed fraud," I said coldly. We went back and forth for 3 hours. Finally, we reached an agreement. Summit Ridge would pay for complete restoration of my lake, including bringing in water trucks if necessary to restore it to its original level. They would pay all my attorney fees, which had reached about $80,000. They would pay me $400,000 in compensation. And they would establish a 30-foot buffer zone around my property, which was less than I wanted but still significant. In exchange, I would grant them a limited easement to run a drainage pipe along the edge of my property to connect their stormwater system to a different outlet, and I would not oppose the development if they stayed off my land and didn't interfere with my water rights. Most importantly, Summit Ridge developers agreed to provide testimony against Patricia Whitmore in the criminal case, if requested by the prosecutor. I signed the settlement agreement with mixed feelings. Part of me wanted to take them to trial and crush them completely, but the practical part of me knew that this was a good outcome. I was getting my property restored and significant compensation, and I was protected from future problems. The check cleared 2 weeks later. My lake was fully restored over the course of a month, with Summit Ridge bringing in tanker trucks of water from a source 40 miles away at enormous expense. They also regraded the damaged areas and replanted native vegetation. By the time they were done, you could barely tell there had been construction equipment on my land at all. But the criminal case against Patricia was just getting started. The county prosecutor had gathered evidence of not just the permit fraud, but also of Patricia's attempts to intimidate me. They had phone records showing calls from her cell phone to me at odd hours, and they had tracked down the person who had spray-painted my cottage, a teenage kid who admitted Patricia had paid him $500 to do it. Patricia was charged with filing false documents with a government agency, fraud, criminal trespass, and solicitation of vandalism. If convicted on all counts, she faced up to 10 years in prison. Her expensive attorneys managed to negotiate a plea deal. Patricia pled guilty to fraud and filing false documents. She was sentenced to 18 months in prison with all but 6 months suspended, meaning she would serve 6 months and then be on probation. She was also ordered to pay restitution to me for the costs of the criminal investigation and was permanently barred from serving on any HOA board in Idaho. I attended the sentencing hearing. Patricia looked diminished in her simple gray dress, nothing like the imperious woman who had stood on my property and threatened me. When the judge asked if she had anything to say, she stood and looked directly at me. "I apologize to Mr. Young," she said, her voice lacking any emotion. "I made poor decisions and I accept responsibility." It was the most insincere apology I had ever heard, but I didn't care. Justice had been served. The Cascade Springs development eventually got built, though on a much smaller scale than originally planned. The 30-foot buffer around my property meant they lost about 20 potential townhome sites, which significantly hurt their profit margins. Several of the investors pulled out, and Summit Ridge developers ended up selling the project to a different company at a loss. Marcus Drummond's company went into bankruptcy 6 months later. As for the HOA itself, Cascade Springs HOA was essentially bankrupted by the settlement and legal fees. The few homeowners who had bought into the development early sued the HOA for mismanagement, and the whole organization dissolved. It was later reformed under a different name with completely different leadership, but it was a shadow of what had been planned. I stayed in Idaho that summer and fall, taking a leave of absence from my job in Seattle. I needed time to decompress and to reconnect with the land that had caused so much trouble. I spent my days hiking around the lake, fishing, and gradually coming to terms with everything that had happened. Bill Henderson, my neighbor, came by one afternoon in early October. We sat on my deck drinking beer and watching the sunset reflect off the lake's calm surface. "You know, Nathan, folks around here are calling you the man who beat the HOA, Bill said with a chuckle. "You're kind of a legend." "I don't feel like a legend," I admitted. "I feel like someone who just wanted to be left alone and had to fight for that right." "That's what makes it matter," Bill said. "Too many people would have just given up, taken the money, and walked away. You stood your ground." I thought about that for a while. He was right in a way. The easy path would have been to take Patricia's initial settlement offer and move on. But some things are worth fighting for, even when the fight is hard and expensive and exhausting. My phone rang, interrupting my thoughts. It was Richard. "Nathan, I wanted to give you a heads up," he said. "The county attorney's office finished their investigation into how the fraudulent permits got approved. Turns out there was a clerk in the planning department who was dating Patricia's son. She admits she fast-tracked the permits without doing the normal verification checks because Patricia asked her to. She's been fired, and the county is implementing new procedures to prevent this from happening again." "That's good," I said. "Maybe something positive came out of all this." "There's something else," Richard continued. "I've been contacted by 3 other property owners in northern Idaho who are having similar issues with HOAs, trying to appropriate their land or water rights through fraudulent means. Your case has opened a lot of people's eyes. They want to know if you'd be willing to talk to them about your experience." I considered that. The idea of helping other people who were in the same situation I had been in was appealing. "Yeah, I can do that. Give them my number." Over the next few months, I became something of an informal advisor to property owners battling HOA overreach. I didn't charge for my time, I just shared what I had learned and connected people with good attorneys. It felt good to turn my negative experience into something that could help others. By the following spring, I'd made a decision about my future. I wasn't going back to Seattle. I resigned from my job as an environmental consultant and decided to start a new career as a water rights consultant in Idaho. My experience with my own case had taught me a tremendous amount about water law, and there was clearly a need for people who understood the complexities of water rights in the western states. I also started developing my property, but on my own terms. I built a small cabin resort with 6 units scattered around the lake, each one designed to blend into the natural landscape. I marketed it as a quiet retreat for people who wanted to unplug and reconnect with nature. It wasn't going to make me rich, but it provided a steady income and allowed me to live on the land I loved. One afternoon in June, almost exactly a year after the whole ordeal had started, I was working on the deck of one of the cabins when I saw a car pull up to my office, which was just the renovated cottage. A woman got out, looking around nervously. I walked over to greet her. "Can I help you?" I asked. "Are you Nathan Young?" she asked. "The one who fought the HOA?" "That's me." She let out a breath. "Thank God. My name is Amanda Logan. I own property about 30 miles south of here, and the local HOA is trying to force me to tear down my barn because they say it violates their architectural standards. But my property was never part of their jurisdiction. I don't know what to do." I smiled and gestured to my office. "Come on in. Let's talk about it. First thing you need to know is that you have rights, and there are ways to fight back if you're willing to stand your ground." As we walked into the office, I reflected on how much my life had changed in 1 year. A year ago, I'd been living in Seattle, treating this Idaho property as a weekend escape and a distant future dream. Now, it was my home and my livelihood. A year ago, I had never imagined I would become someone who fought HOAs and won, someone who other people came to for help. The battle with Cascade Springs HOA had been brutal and expensive and stressful. But it had also taught me something important about myself. I was stronger than I thought. I could stand up to bullies with money and power and connections. I could navigate complex legal systems and come out on top. And most importantly, I could protect what was mine. As I sat down with Amanda and started asking her about her situation, I felt a sense of purpose I had never experienced in my old career. This was what I was meant to do, help people protect their rights and their property from those who would take them by force or fraud. The lake outside my window sparkled in the sunlight, exactly as it had for over a century, and exactly as I intended it to remain for centuries to come. Patricia Whitmore had tried to drain it to build her townhomes, but instead, she had awakened something in me that couldn't be drowned or drained or intimidated. She had tried to take my water rights, and in doing so, she had lost everything. Summit Ridge developers had lost millions, the HOA had been bankrupted and dissolved, and I had gained not just compensation and restored property, but a new life and a new purpose. Looking back, I almost wanted to thank Patricia for her greed and arrogance. Without her attack on my property, I might never have discovered the strength I had inside, or the calling that now drove me forward. I might have stayed in Seattle, unfulfilled and disconnected from the land that was my heritage. Instead, I was here, in northern Idaho, living on property that had been in my family for 3 generations and would hopefully be there for 3 more. I was helping other people fight the same battles I had fought, and every day I looked out at that lake and remembered that some things are worth fighting for, no matter the cost. The water rights that my grandfather had secured in 1953 had saved me. They had been a piece of paper filed away and mostly forgotten, but when the crisis came, they had been the weapon I needed to defend my property and my rights. It was a reminder that our ancestors' foresight and diligence could protect us even decades later, and a reminder that I had a responsibility to protect this land for my own descendants, whoever they might be. As summer turned to fall and fall to winter, my little resort began to gain a reputation. People came from all over the Pacific Northwest to stay in my cabins, to fish in the lake that had almost been destroyed, to hike the trails I had developed around the property. Some of them were lawyers or activists or just curious people who had heard about the case and wanted to see the place that had been at the center of such a dramatic legal battle. I told them the story, sometimes sitting around campfires in the evening. I told them about Patricia Whitmore and her threats, about the moment I realized I had the water rights, about the court battles and the settlement and Patricia's eventual conviction. I told them not to scare them or to make myself seem like a hero, but to teach them that ordinary people could stand up to powerful interests and win if they were willing to fight. One cold evening in December, I got a call from Richard. We had stayed in touch and he had referred several clients to me for water rights consulting work. Nathan, you're not going to believe this, he said, excitement in his voice. Remember how we sued Summit Ridge for fraud and trespass? Well, their bankruptcy filing has been going through the courts, and it turns out they had insurance that covers some of the claims against them. The insurance company just settled with several of the investors who lost money on Cascade Springs. But here's the interesting part. The insurance company is now suing Patricia Whitmore personally to recover their costs, claiming she defrauded them by misrepresenting the viability of the project. Good, I said simply. Patricia had served her 6 months in jail and been released on probation, but she had never shown any real remorse for what she had done. Maybe a massive civil judgment would finally make her understand the consequences of her actions. There's more, Richard continued. The state HOA regulatory board has used your case as the basis for new regulations on HOA formation and governance. They're requiring much stricter oversight and accountability. Your fight has literally changed the law in Idaho. That news hit me harder than I expected. I had fought for my own property, my own rights, but the ripple effects had gone far beyond my small corner of northern Idaho. Other people would be protected because of what I had endured. Future H. As would have to follow stricter rules, making it harder for them to abuse their authority or commit fraud. It wasn't just about me anymore. It had never been just about me, really. It was about the principle that property rights meant something, that legal documents like deeds and water rights certificates had to be respected, and that no organization, no matter how well-funded or well-connected, could simply take what belonged to someone else. Spring came again, bringing new guests to the resort and new consulting clients to my water rights practice. I hired an assistant, a recent college graduate named Sarah Montrose, who was passionate about environmental conservation and water law. She helped me manage the growing workload and brought fresh energy to the business. One warm afternoon in May, almost 2 years after the initial drainage of my lake, I was conducting a property survey with a client when I noticed a car parked by the lake's edge. It was a modest sedan, not the kind of expensive vehicle that Patricia had driven. A man in his 20s got out and stood looking at the lake, hands in his pockets. I excused myself from my client and walked over to him. "Can I help you?" He turned, and I saw tears on his face. "I'm Justin Whitmore," he said quietly, "Patricia's son." I tensed, unsure of what to expect. Was this going to be a confrontation, a threat? "I came to apologize," Justin continued, "for what my mother did. I know it doesn't mean much coming from me, but I need you to know that not everyone in my family supported what she did. I testified against her at her trial. I told the prosecutors about the things she said at home, about how she planned to intimidate you into selling. My testimony helped convict her." I studied him for a long moment. He looked genuinely remorseful, nothing like his mother's cold arrogance. "Why did you testify against your own mother?" "Because what she did was wrong," Justin said simply. "She's always been like this, entitled, convinced she's better than everyone else, willing to do whatever it takes to get what she wants. I'm tired of making excuses for her. When I saw what she did to your property, I realized I had to take a stand. It cost me my relationship with her, probably permanently, but it was the right thing to do." I felt my anger at the Whitmore name softening. "Thank you for telling me this, and thank you for having the courage to testify." Justin nodded. "The insurance company's lawsuit is going to financially destroy her. She'll probably have to declare bankruptcy. Part of me feels guilty about that, but another part thinks she brought it on herself." "She did," I said. "Actions have consequences. Maybe this will finally teach her that." We talked for a few more minutes, and I learned that Justin was working as a teacher in Boise, trying to build a life separate from his mother's influence. Before he left, he shook my hand. "I'm glad you won," he said. "I'm glad you fought back. The world needs more people like you." After he drove away, I stood by the lake for a long time, thinking about everything that had happened. The water was clear and calm, reflecting the blue sky and the surrounding pine trees. Fish jumped occasionally, leaving ripples that expanded outward in perfect circles. It was peaceful and beautiful, exactly as it should be. I had fought to preserve this place, and in doing so, I had preserved a piece of Idaho's natural heritage. The lake had been here long before me, and if I did my job right, it would be here long after I was gone. That thought gave me more satisfaction than any amount of money could have provided. The summer tourist season brought a steady stream of guests to the resort. I hired additional staff to help manage the cabins and grounds, and Sarah proved invaluable in handling the water rights consulting business. We took on cases throughout Idaho, and even some in neighboring Montana and Washington, helping property owners understand and defend their water rights. In August, I received an invitation to speak at a conference on property rights and HOA reform in Boise. I was nervous about public speaking, but Richard encouraged me to do it. "Your story needs to be heard," he said. "There are legislators at this conference, policymakers, people who can make real changes. You have the credibility to influence them." So I went to Boise and gave a speech about my experience. I talked about the importance of protecting property rights, about the need for accountability in HOA governance, and about the critical role that water rights played in Western land management. The audience, which included several state legislators and the Idaho Attorney General, listened intently. After my speech, a state senator named William Trent approached me. "Mr. Young, that was powerful testimony. I'm working on legislation to reform HOA laws in Idaho, and I'd like to consult with you on some of the provisions. Would you be willing to serve as an advisor?" I agreed, and over the next several months I worked with Senator Trent and his staff to help draft new HOA legislation. The bill, which became known as the Property Owner Protection Act, included provisions requiring HOAs to conduct thorough property verification before filing for any permits that could affect private property, mandatory insurance requirements, stricter penalties for fraud, and easier paths for property owners to challenge HOA actions. The bill passed the Idaho legislature with strong bipartisan support in March of the following year. At the signing ceremony, Governor Jeffrey Walsh invited me to stand beside him as he signed it into law. "This legislation wouldn't exist without Nathan Young's courage and determination," the governor said in his remarks. "He refused to be bullied. He stood up for his rights, and in doing so, he's helped protect the rights of property owners throughout Idaho." Standing there in the governor's office, watching him sign the bill into law, I felt a profound sense of accomplishment. The fight with Cascade Springs HOA had been painful and difficult, but it had led to something larger than my individual case. It had led to real, meaningful change that would protect other people in the future. I thought about Patricia Whitmore, serving her probation and facing financial ruin from the insurance company's lawsuit. I thought about Summit Ridge developers, bankrupt and dissolved. I thought about the Cascade Springs HOA, reformed and operating under new leadership with much stricter oversight. And I thought about all the property owners who would benefit from the new law, people who would never know my name but who would be protected because of the fight I had waged. It had all been worth it. I returned to my property in northern Idaho with a renewed sense of purpose. The resort was thriving, the consulting business was growing, and I had found a community of friends and colleagues who shared my passion for protecting property rights and natural resources. One evening in late spring, 3 years after the drainage of my lake, I sat on my deck with a glass of whiskey and watched the sunset paint the sky in shades of orange and pink. The lake reflected the colors perfectly, a mirror of natural beauty. I could hear guests laughing in one of the distant cabins, and somewhere an owl hooted as it began its nightly hunt. This was home. This was peace. This was what I had fought for. My phone buzzed with a text from Sarah. One of our clients had just won a major water rights case using the precedents we had helped establish. Another victory. Another person protected. I smiled and raised my glass to the lake, to my grandfather who had bought this land and secured the water rights so many decades ago, to my father who had maintained it, and to all the unknown people who would benefit from the fights we had fought. Patricia Whitmore had tried to drain my lake to build townhomes. She had thought she could intimidate me, buy me off, or bury me in legal fees. She had been wrong on all counts. I had pulled the water rights, fought back with every tool at my disposal, and in the end, I had bankrupted not just her HOA, but also the development company and Patricia herself. But more than that, I had sparked a movement for property rights protection that had changed laws and protected countless others. I had turned my family's land into a thriving business that honored its natural beauty. And I had found my true calling in life, helping others defend what was rightfully theirs. The water rights my grandfather filed in 1953 had been the key to everything. Those old documents, carefully preserved and maintained across 3 generations, had given me the leverage I needed to fight back and win. They were a reminder that the decisions we make today can protect our descendants far into the future, and a reminder that we have a duty to preserve and protect for those who come after us. As darkness fell and the stars began to appear over the lake, I felt a deep contentment. The battle was over. The war had been won. And the lake that Patricia Whitmore had tried to drain continued to flow, just as it had for over a century, just as it would for centuries to come. That was my legacy, and I was proud of it.